I want to thank you for joining us for this third town hall meeting here at the Department of Human Services. As we've mentioned the last couple of weeks, we're going to be having 8 of these. This morning we're focusing on child support enforcement, and I have with me Chad Shook, who's the director of our Division of Child Support Enforcement. Chad, glad to have you with us.
Thank you, Bob. Thanks, sir.
Just to remind you, we have received some questions in advance, and we will get to some of those questions in just a few minutes. I will remind you also that if you have questions while you're listening to the town hall, watching the town hall, they need to be on the topic of child support enforcement, and we'll get to as many of the questions as we can when we get to that part of the session. What we want to do this morning is give you an overview of the work of the Division of Child Support Enforcement. But just for a minute, Chad, before we do that, I hear words, and I'm sure our audience has heard words that have to do with child support. And I want you to just kind of give us a brief understanding of the phrase putative father, for example. What are we talking about when we talk about a putative father?
Putative father is a suspected father. They haven't undergone genetic testing yet, but they are suspected or a candidate to be the father. And so that's what we mean by putative father.
Okay. And then I hear also this phrase, establishment of paternity. What is that all about?
Well, in order to, there's several different ways it can happen. The most common is what we call ASAP. It's a simple acknowledgement of paternity that is completed generally at the hospital after the child is born, and both the parents will sign off on those documentation at the hospital. If that doesn't occur, then you go through the paternity establishment process by filing a petition in Chancery Court. And DNA test, genetic testing is conducted on both the child and the putative father.
Okay. And is there somebody that the Department of Human Services uses generally to do that genetic testing?
When you file your petition or when a petition is filed for paternity establishment, there's a contractor who will be at the court generally on the day of your hearing where that will occur. In some cases, they may send you to a provider wherever their office is, but generally it's done at the court on the day of the hearing or when you're at court.
Okay, so we allow an acknowledgement, the courts allow an acknowledgement of paternity by a dad.
Yes.
But also there's this DNA testing that's
right.
done once a petition is filed.
That's correct.
All right, so let's walk through a little bit about what the general work is of the Child Support Enforcement Division. Tell me a little bit about support orders. What are those exactly?
Well, support orders, again, they can be initiated through a variety of different processes. If someone applies for SNAP benefits, for example, then there is a requirement under federal law that you also cooperate in the establishment of child support in order to support both those programs. If that is not the situation, then you, again, as you do with paternity, you file a petition in Chancery Court, and if paternity is acknowledged, then the father would be served if he is the non-custodial parent. And then the court would determine, based on their child support guidelines and based on the non-custodial parent's income, how much support would be required on a monthly basis.
Okay, so when we're talking about custodial and non-custodial parents, I mean, it's self-evident, but custodial parent is the parent who has the child living with them, right?
That's correct, yes.
And non-custodial, obviously, is the other parent whom the child is not living with.
That's correct, yes.
Okay. What kinds of problems arise, or do problems arise, regarding support orders?
Problems can arise. In my experience, the primary issue is that once an order is entered, once the parties or once the non-custodial parent has a support order in place, it's very important for the custodial parent and the non-custodial parent to abide by that court order. and not go outside that court order because we as a department, as a division, are bound by the last order that the court has entered. So can I give an example?
Sure.
So let's say, for example, the non-custodial parent is under an order to pay child support on 3 children who are living with a custodial parent. And when one of the children is 15 years old, they decide they want to go live with the non-custodial parent. And the parents agree to that, but they don't notify the court or notify us. Well,
okay.
The non-custodial parent is now paying support because the court order requires he or she to do so on a child that's living with him. And until that order is modified by the court, that is what we are bound to follow.
Okay. So if a child moves from the home of the custodial parent and goes and lives in the home of the non-custodial parent, does the support obligation end necessarily?
No, not until the court order is modified. Now, the obligation probably would be modified if a petition for modification is filed with the court, but we are bound by the existing court order until it is modified by the court.
Okay. And these orders are all entered in Chancery Court, you said?
Yes.
Okay. So under Mississippi law, the Chancery Courts have, do they have exclusive jurisdiction on these child custody matters?
On custody and support, the Mississippi Constitution vests the best interest in all minors matters or children's matters with the Chancery Courts. Now, in some cases, we have modifications that may be heard in a county court if your county is large enough to, but I would venture to say above 98% of our cases are heard in the Chancery Courts or even through a family master that is appointed by the Chancery Court.
Okay. I had a note here, and this may have been one of your cases. Well, let me ask you this. You had experience before coming to the Department of Human Services, practicing law and handling support matters.
Yes.
And I had a note here about a situation where a non-custodial parent was living in Iowa with 3 children in Mississippi. And then the court established custody of the children in Mississippi, and the children then went to live with the other parent in Iowa. But the parent in Iowa was still being charged child support in Mississippi?
Yes, and that's why I mentioned earlier it's important that the parties abide by the court order or have that order modified, because the Mississippi court order required the non-custodial parent to pay the custodial parent child support on the 3 children living with her. And then when the children ended up living with the non-custodial parent out in Iowa, then obviously the support should have been modified, but it wasn't by the parties. They just did that on their own outside the court order. And so we are bound by that court order until they have that modified.
Okay, so the message is mom and dad can't get together and just work things out. They need to go back and tell the court what they're doing.
You're right, yeah. They can work things out, just let us know that they've worked them out.
Sure. The court needs to modify. If
exactly
they've modified
right.
their circumstances,
Right.
then the court needs to adopt the support order
Exactly.
to agree with their changed circumstances.
That's exactly right, yes, sir.
Now, we're talking about MDHS doing these support orders and going to court. Is it actually MDHS lawyers in most instances or not?
Now, MDHS contracts with a private contractor that provides our legal services for us, and they are housed in regional offices throughout the state of Mississippi. They represent MDHS, but they're actually operated by our third-party contractor under contract with the state.
Okay. So when somebody goes into a local child support office I know there's one in Madison County, for example, on County Line Road.
Yes, sir.
That child support office it has MDHS's name on the face of it.
Right. That's
But
right.
it's actually operated by a contractor.
That's right. That's
Okay.
exactly right, yes, sir.
And my understanding is that's been the case for about 3-4 years now?
Yes, at least 3 or 4 years, yes, sir.
Okay.
Yes.
All right. Tell me about something called the perennial review that this division undergoes. What's that all about?
In 2022, the Office of Child Support Enforcement, which is a sub-unit of the U.S. Department of Health and Human Services, require the states every 10 years to review our child support guidelines. Currently, those guidelines are set at 14% for one child of your adjusted gross income, and it taps out at 26% for 5 or more children, and so that's the range. And so we have to review those guidelines to make sure they are consistent with income levels in the state and consistent with other factors that are considered appropriate amounts of support. So we have to review those every 10 years. They may be modified, they may not, but we're required to review those every year. And if they have to be modified, then that requires legislative action. We would have to consult with the legislature and get those modified. Otherwise, we would be, if they're not modified, we would review them again in another 10 years.
Okay. And are all of those guidelines, are they posted somewhere? If somebody wanted to look at those, are they on our website or someplace?
I don't know they're on the website. They are in the Mississippi Code,
Okay.
and you can Google Mississippi Child Support Guidelines, and it will take you to various links that provide that information for you.
Okay, so they're all incorporated actually into the Mississippi Code.
They are, yes, sir.
All right. Now, does the state also, you mentioned the Office of Child Support Enforcement, that's our federal oversight partner.
That's correct.
Does the state have to prepare a state plan or something to submit to Office of Child Support Enforcement?
We do. We have a very substantial state plan that's it's kind of a moving document. It's modified in different parts and different pages every year. We have annual updates to the state plan based on directives from OCSE, the Office of Child Support Enforcement, as to what we have to modify. So.
Okay. And do you have an idea? I know there are literally hundreds of thousands of cases. What is the caseload for child support cases in Mississippi right now?
It, of course, as you point out, it kind of fluctuates somewhere in 265,000 case range is kind of where we are generally. I don't have a specific number, but that's give or take a few hundred cases. That's where we are.
So those are scattered out all over throughout all 82 counties, basically.
That's correct. Yes, sir.
Okay. Now we introduced. I say we, the legislature. Senator Fillingane introduced a number of child support bills during this current legislative session that are kind of winding their way through the process. There's one that deals with incarcerated parents. What is that bill all about?
Well, if you have a non-custodial parent who is under a child support order and they are committed to the custody of the MDOC, Mississippi Department of Corrections, and they are incarcerated at either one of the regional facilities or one of the state prisons, then their child support currently continues to accrue while they are incarcerated. And this bill would, and so that when they come out of their incarceration, their arrearages or their back child support is not very high, because obviously if you're incarcerated you can't pay child support, because you're if this bill is successful, which I hope it will be, your child support when you go into MDOC would be suspended, and then upon your release after 60 days it would automatically resume. So give you 60 days to get out, get back on your feet, get established, and then your support obligation would resume at that point.
Now, is this idea about suspending child support while a parent is incarcerated, is that our idea, or is that something that OCSE has asked us to consider?
That's something that the federal, our federal partners have asked us to consider, and there are other states around the country that have followed that same plan, so that we have we're more consistent around with other of our partners around, or other states around the country. So.
Now, there's also a bill that deals with imputed income. What is that? Well, first of all, what are we talking about when we say imputed income, what is that idea exactly?
Imputed income comes into play when someone is unemployed or they have a work history and they're not currently employed, and the court is asked to impute or to presume based on their work history, or most commonly based on the current minimum wage, a certain amount of income in order to set child support by. So that's what we mean by imputed income.
Okay, and the bill that's in the legislature, what would that do exactly?
It would modify what a chancery court or a family master appointed by chancery court could consider as imputed income, and what factors could be considered in that regard.
Does it require the court or suggest the court just look at the actual circumstances of the parent?
That's right, exactly,
Okay.
yeah, actual circumstances.
I misstated earlier, these child support bills are actually in the House, and were introduced, a couple of them introduced, well, 3 of them introduced by Representative Shonda Yates, I believe. So, there is another bill that has to do with the means by which child support orders and things of that, child support documents can be served on financial institutions. Doing away with a certified mail requirement. What's that all about?
It's a matter of streamlining how we're able to communicate with financial institutions about potential sources of child support collections. It makes that process a little simpler than it is now currently.
Does it allow the Division of Human Services, the Department of Human Services, and your division to just use regular mail going forward if that becomes law?
That's right, yes, sir.
So we save the cost, the state will save the cost of that certified mail.
Exactly.
All right. Now, there's also a bill that deals with the treatment of lump sum payments when there are arrearages. Can you tell us a little bit about that bill?
That bill has my understanding, has gone through some changes in the legislative process, and so I'm honestly not sure where that is at this particular time. I know it's been introduced, but I don't know the status of it.
Well, it's actually come out of the committee.
Oh, okay.
And I mean, does it relate to how much the child support division can reach of a non-custodial parent?
Yes, it does. Yes.
Okay.
Yes.
In circumstances that might include a lump sum, would be a lump sum payment by an employer, for
That's
example?
right. That's exactly right.
Okay. And my understanding is this is another one of those statutory requirements that we've been asked to seek by the Office of Child Support Enforcement.
That's correct. Yeah, as our federal partners, we work very closely with them, and they encourage us to make these statutory changes, and we do our best to comply. We have to comply, and that's a general rule with what they ask us to do. So.
All right. Well, tell us a little bit about the Mississippi Access and Visitation Program. What is that in the child support program?
The Mississippi Access and Visitation Program is a federal grant that we receive every year from the U.S. Department of Health and Human Services. That the goal of the grant and the work of the grant is to increase the amount of parenting time or visitation that a non-custodial parent has with their children. And so we have a dedicated person in the office that fields calls from the grant and tries to assist parents in working through visitation issues that may arise between them. They're also, we're on March the 1st, we are starting a pilot project with 7 chancery courts around the state that will provide mediation services for parents who have visitation disputes. And we're really excited about that program starting on March the 1st. We're partnering with our friends at the Administrative Office of Courts to assist in that. And that pilot will run through September 30th of 2021. And then we're hoping to expand it in the next couple of years, hopefully, eventually, if it goes well, to all 82 counties.
Okay. So the mediation aspect of that, is that just to get custodial parents and non-custodial parents together to try to work out some kind of visitation arrangement?
That's right. Yes, sir.
They can both agree to?
They both agree to, and a lot of times it's hard for the parents themselves to work through those issues for a variety of reasons, and so a mediator is a neutral third party that would be designated by a court, and they would sit down around a table with the parents and try to develop a parenting plan or a visitation plan, a holiday visitation plan, and things of that nature for the court's consideration. Ultimately, our goal with child support, really anything dealing with children, is achieving the best interest for the children, what's in the best interest of the child, and so that's the goal, and the mediators can assist the parents in developing those plans.
Okay. Well, we got a lot of questions that were pre-submitted before we got started today. Some of them were case specific, and unfortunately, we're not going to be able to answer any that are specific to one case. We're just not, from a privacy standpoint, we can't share that information in this setting. Certainly, if you have a question about your own case, you can contact us, or you can contact the contractor and talk with one of the attorneys or one of the case managers about your case. But there are a lot of questions here that are about the program itself that I think we can talk about.
Sure.
Tell us again, what is the rationale? What's the reason that when a family applies for TANF, Temporary Assistance for Needy Families, or SNAP, the Supplemental Nutrition Assistance Program, why is it if their children are receiving child support that they are required to cooperate with the child support program?
That's a federal requirement that if you have an able-bodied, an individual who is a non-custodial parent who can support or provide financial resources for their children, and those children are on these assistance programs, it's imperative that they cooperate with child support so that we can attempt to have those non-custodial parents provide support for the children that help offset the cost of the other federal programs.
Okay. And if any parent who believes child support is owed wants to go through that process, they just go into one of these regional offices around the state and put in an application for assistance? That's
right. And you can call. There's a you can call and start the process over the phone. So it's a fairly streamlined process, an easier process to do that. And then once the application is completed, that kicks off the process and it goes through.
Okay. Do they need to actually hire a lawyer to do that?
No, they don't. They don't have to. They, as a custodial parent, they can go into one of our regional offices and start their process, or call and start the process, and then the lawyers of the contract, they represent the state, but the custodial parent is the representative of the children that are subject to the child support request.
Okay. Well, we hear a lot, and I'm sure your division hears a lot of complaints from time to time about delinquent child support payments. Why isn't it that contempt of court is an automatic result when a parent is behind on child support?
A couple reasons for that. One is logistics. I know it's important when a child support order is in place. Let's say you've got a child support order for $200 a month from the non-custodial parent, and custodial parents bank on that money coming in, so it's important that they get that. But if the non-custodial parent misses 1 month, for example, by the time you go to get a contempt petition filed and get that set on the court's docket, a lot of times they will have cured the arrearage by the time the case will be set for hearing. So, in order to have an effective contempt process, you have to allow for the time that it takes to prepare those cases for trial.
Okay.
So.
Is there some rule of thumb, like a certain amount of arrearage triggers the contempt process?
It's a case-by-case analysis. There's nothing really that it's going to be based on the facts of a particular case.
Okay. Now you mentioned ways to apply. Is there an online portal available at this time, or is there any thought about having
There's thought.
online portal?
I'm sorry. Yeah, we're talking about, we're hoping to streamline this process so that you can do it from the comfort of your home. You can, or from your smartphone. You can apply for all of these various programs. We're hoping to get that developed and available to the public in the not too distant future.
But it's still in the planning stages right now.
That's right.
Okay. Yes. Well, I'm sure that a lot of parents and non-custodial parents, particularly, have dealt with unemployment, being out of work during the pandemic. What happens to child support payments, or what has been happening to those child support obligations during the pandemic?
Well, if the first round of stimulus funds, for example, that came out in I think March of 20, those were the support obligations came out of those, and it took several months to get all of those. And actually, we have until March 31st of this year to clear all of those holes that were placed on those stimulus funds. The $600 stimulus from December, that was not subject. Congress exempted that $600 from child support obligations, and so those funds were not affected by that. So unemployment is subject to child support obligations too, and so if there's funds there, so there's various different mechanisms but the pandemic has been hard on everybody, and so we've had unfortunately a lot of folks just unable to meet those obligations during the course of the pandemic. So.
If a non-custodial parent is receiving unemployment compensation, is the amount of child support adjusted at all, or does it remain the same? Unless you go back to court, does the obligation stay the same?
Obligation stays the same. There are limits on what can be taken from a unemployment benefit, but the obligation remains the same. It's a court order that must be modified by the court.
Okay. Another member of our audience asked about what about garnishing SSI checks? Is that possible? Social Security checks? Can they be garnished for child support?
Social Security, certain aspects of Social Security can be garnished, but not all types of Social Security. Traditional Social Security can be garnished, but there's a certain class of Social Security that are protected from garnishment, and so we have to analyze that and make a decision based on what the individual is drawing from SSA before we can put in an income withholding order to SSA.
Okay. I want to talk to you a minute about a program we're considering here, and that's the child support pass-through, which is not in place. About 28 states are using a pass-through. Could you explain to the audience a little bit how a pass-through would work?
Yeah, the pass-through is, again, something that we are considering, and I certainly support, and it would get more monies into the hands of the families that we serve. It would permit us. The pass-through permits us to pass through more child support monies without affecting eligibility for other benefits to the families that we serve. So.
Okay, so if the pass-through, if we adopt a pass-through program, that won't have an impact on a family that's receiving SNAP benefits, for example.
It will not affect their eligibility, no, sir.
And if they're receiving TANF benefits, it won't have an impact on their TANF.
No, sir.
That child support money that's passed through is not counted for TANF
that's right.
or SNAP. Okay. What kinds of fees are involved? I mean, and who pays the fees if there are fees in these cases?
Filing fees for filing the petitions are borne by the state, but if we are successful in a child support obligation, we ask for those fees to be paid back by the non-custodial parent. The fees are paid through the chancery clerk or through or they're paid through SDU. There is a handling fee that's charged, and that's over and above the support that comes out, and that is charged also to the NCP, a processing fee.
Okay, so the processing fee is not charged to the custodial parent at all, or is it?
No, sir.
Okay. You mentioned the SDU. My understanding is that's something called the State Disbursement Unit?
Yes, sir. Yes.
And is that the office or is it a vendor or is it an actual office of child support division?
It's a vendor, just like our legal services vendor. It's a vendor, and they collect all of our child support, and they disperse it to the custodial parents.
Okay. And do they make any judgments about how much to disperse, or do they just pass through what they actually receive?
They pass through what they actually receive, yes.
So if they receive from a non-custodial parent $2 in a month,
Right.
they pass that through to the custodial
That's exactly
parent?
right. That's correct.
Okay, all right. How often does child support, does the division update information to policy data about parents who don't comply with child support? Do we report that to anybody?
Yeah, it's reported on a regular basis, at least annually. Quarterly reports are prepared that go to certain entities, and as from a child support policy perspective, we have a policy unit, and so we are continually revising and updating our policies to make sure that we are complying with federal regulations and make sure that we are consistent with our Mississippi program with what's required by our federal partners.
Okay, so that policy unit is internal to the Department of Human Services?
That's correct. Yes.
That's within your division?
Yes.
Here. Okay. What happens if the non-custodial parent is being paid cash? If the custodial parent learns that non-custodial parent is getting paid cash, how does that work?
It's really very difficult, virtually impossible to track cash payments that an NCP or non-custodial parent may be receiving because there's no record of that. And so you hear that quite often, that they'll say, well, my ex or the father or the mother, as the case may be, is getting paid in cash to do whatever job they're doing. And so there's really, if it's cash money, if there's no financial records, it would be imputed at the minimum wage, is what the support would generally be set out.
So that's kind of where that imputed income idea comes in.
That's correct, yes.
We have a question here. It says, my children's dad pays child support. I know because I see the check stubs, but half the time I don't receive it. Over $300 is missing. Child support won't tell me where it is. Is that do you have any idea why that might be?
I don't, but I would encourage that that consumer, that customer to call, and we can certainly help her find the answer to that question. So
okay.
Now there sometimes is a slight delay once the money comes through, but we're SDU, the State Disbursement Unit, is supposed to pass that money out very quickly once it comes in. So there shouldn't be a huge delay there.
Okay.
Now, sometimes we'll see that employers don't always, they don't make regular payments necessarily and so we can't disperse it until it comes in. And so if an employer does not timely submit it to us, that could be part of the reason for the delay. But I'm just speculating on those particular facts of this case that have to be investigated.
Right. So an employer, is that in the circumstances, for example, where the child support obligation has been handled by a garnishment to the employer?
Yes, that's right.
And they're taking that child support obligation as a payroll deduction, essentially.
That's correct, yes.
And the employer is required then to forward that money to the State Disbursement Unit?
Yes, that's correct.
Okay. Sometimes there's a little bit of delay in that process.
Yeah, I mean, employers, sometimes they'll do it monthly, they'll do it bi-weekly, they don't, it doesn't necessarily go to SDU the same day it comes out of the person's income.
Okay. Another member of our audience asked, even parents who are not on TANF are not receiving all the money being paid in. Why is that? Any thoughts on that, Chad?
I don't. Again, that's a question that we could certainly be investigated. If they have an active child support case with a case number, we could certainly investigate that if they would call in. So.
Okay. Now, the only way that, I have another question here about changing who receives the payment. The only way to change who receives the payment is for the party to go back to the Chancery Court, is that right?
That's correct, yes, sir.
Okay. Could some of the funds that for a parent, you know, who's not receiving all the money, could it be maybe the court cost is responsible for some of that?
Could be. That could be part of the, that could be one of the reasons they're not getting the full amount, especially if it's a new case that just started. So. Okay.
What, any idea how many cases are handled by garnishment? Is that a large number of the cases?
If the non-custodial parent is employed, garnishment is the preferred way because it's automatic. You don't have to think about it. Non-custodial parent don't have to think about it. It's just you get the check, it's ordered out, so and it's coming in. So that's the preferred way. And we, I don't have a specific percentage, but the greater majority of folks who are employed that are non-custodial parents pay their support with IWOs, income withholding orders.
Okay. We're going to try to wind it up here in just a minute. Let me ask you, in regard to winding things up, what terminates a non-custodial parent's obligation to pay child support?
Those are statutory provisions, but primarily when a child turns 21, when they become emancipated, meaning they are legally adults, and they can be by marriage. If a child, I say a child, if a 17-year-old gets married, then they are emancipated at that point. If they join the military, or if they go into a chancery court and are able to persuade a chancery court judge that they need to be emancipated, you can file a petition for emancipation, and it can be accomplished that way as well.
So when the child reaches the age of 21, does that terminate the child support as a matter of law, or does somebody have to go back in court to make that happen?
Terminates as a matter of law at age 21.
So that's one of the few instances where the court doesn't actually have to do anything.
That's right. Yes, sir. That's right.
But if a child is emancipated, I would assume then somebody needs to advise the chancery court that that child's been emancipated and there's no longer an obligation to pay support.
That's correct. And there's, I think, some people may believe that 18 is that number that automatically ends at 18, but it doesn't.
Okay.
Because a child turns 18, that's it's still an obligation until 21 unless it's modified by the court.
So when a child goes off to college, that child support obligation still continues until the child is 21.
21 years old, that's correct. Yes.
Okay. I think we've got one more question here. Let me ask you, I know the division receives a good number of contacts from custodial parents. Any sense about what kinds of issues you see most often in these cases?
Usually it's they haven't received a payment or they have gone in and started the process, but they haven't been to court yet. So that's been the issue in the last year with the pandemic. But of course, a lot of our courts were forced to modify how they function because of the pandemic. So that has caused a delay in some cases being heard in the last year, especially.
Okay. Another question we have is, what do I do if my child's father has his own business, but he hides? Is he obligated to pay fines? If he hides his income from that business?
I mean, if it's a cash business, I mean, it's just like being paid in cash. If he's being paid in cash for that work that he's doing, if it's a business that that he's not necessarily paid in cash for, it's potentially easier at least to try to track some of that money down, but it's
Okay.
much more difficult if he is trying to subvert that money. So,
One last question. I've heard, and I'm sure some of our audience has seen, cases about deadbeat parents actually being prosecuted for child support arrearages. How does that happen?
A couple of different ways that can occur. There's a federal statute that permits the U.S. Attorney's Office to prosecute parents for non-support, but in that case, the non-custodial parent must live outside the state of Mississippi, and the custodial parent and the child must reside in Mississippi. So that's the hook, if you will, for the federal statute to come into place.
Good.
We also have a non-support statute in the Mississippi law, and those are handled by the Attorney General's office. They have a dedicated special assistant Attorney General that handles those cases all over the state, and they will take those cases if an arrearage is over $10,000 and the child is less than 18 years old. That's the criteria for the Attorney General to take a case. And then the other mechanism is our local district attorneys obviously could prosecute those cases if it's brought to their attention and they choose to do that.
Okay. Is there any kind of hotline number that's set up for child support complaints or problems?
There is a 1-800 number. I don't have it memorized, I'm sorry, but there is one.
All right. Well, we'll put that out on our Facebook page,
Yes,
and I'm sure it's probably on our website
it is,
someplace.
yes.
We're going to need to kind of wrap things up. Next week, we will be talking with Sharon Butler, who is the director of our Division of Economic Assistance Eligibility. And that session is set for 2 p.m. I'm seeing now the number, the hotline number is 877-882-4916. So if you have a complaint, you have a problem about your child support case, you can call that number, 877-882-4916. Chad, I want to thank you for giving us some of your time this morning and explaining to our audience how the Child Support Division functions, what its work is, and why we're involved at the Department of Human Services in the child support function. Thank you very much. We'll see everybody next week. Again, we're at 2 p.m. next week, and we'll be talking with the Division Director, Sharon Butler, for Economic Assistance Eligibility. Thank you very much.